Sorry? No, in mediation, yes, that's right. So all that we can see is that, see, both of them are now saying there are no children, there are no claims. They want a decree of divorce, but due to the peculiar circumstance of the case, they could not file a 13B or 10A, whatever petition, and they were here in this court. So in such cases are referred to. All that we can do is to see whether reconciliation is possible, whether there are any chance. Otherwise, for declaratory relief, it goes back to the court. Correct? Is there anything that we want to add on this? Anyway, let's work on that. Please talk in the mic, ma'am. Now let's look at another situation. Two ladies, there's a dispute to declare that she is the legally wedded wife, and there's a claim and counterclaim by the children and the wife and spouse. The second wife is notified as the nominee under all the service benefits. So there's a dispute regarding this terminal benefits of the deceased husband. Now this matter is referred to mediation. There is a declaratory relief that is sought for. Now can we handle this in the mediation? Can we take up this case? Is it fit for mediation or not fit for mediation? Ma'am, speak in the mic, ma'am. Prema ma'am, yes. Let me give a chance to others who speak behind. I think you have got the concept well. Anybody wants to add? Kala? ಮಾಡಬಹುದಾ? ಬೆನಿಫಿಟ್ಸ್ನ ಹೇಗೆ ಶೇರ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಅದನ್ನು ನಾವು ಪಾರ್ಟಿಗಳು ಅವರ ಒಪ್ಪಿಗೆಯಿಂದ ಇತ್ಯರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋಕ್ಕಾಗತ್ತಾ ಅಂತ ನಾವು ಪ್ರಯತ್ನ ಮಾಡ್ಬೋದು ಅಲ್ವಾ? ಎಸ್ ಆರ್ ನೋ? ಎಸ್. Well, there's a counter here saying no, it can't be done. Only the legal wife will get the benefits. Then, ma'am, I'll have to let's go back to the judgment of the Supreme Court when saying what are the rights of children who are born in a void marriage or a second marriage. So they are eligible to claim the benefits as which is their father's, not the ancestral property, but they can. So what is the property of the father? The second wife children also have a claim on that. So now we can see whether they can address this dispute. But with regards to the validity of the declaration of the validity of the legally wedded wife, it is the court that has to decide. Correct? Now let us look at another scenario. We see this very often, it's happening. Parties get engaged. In their eagerness to go to America, they get their marriage registered. However, they call off the engagement. Now they have a document which showing that is their registered marriage. Now they seek for declaration that is not a marriage and the marriage certificate has to be cancelled. Can this be referred to mediation? Can we mediate on this? agalla, can't be done. Any other view on this? We have also seen situations where marriages have taken place in the lawyer's office or before a notary. Some certificate has been issued, and based on the certificate, they believe that there is a marriage and they have lived together. And later, when there are differences, they have now discovered that it is not a valid marriage, and such a petition has been filed in the court to declare the marriage is not valid. Now, can this be referred? Can we handle this? So far as declaratory relief, it has to go back to the court. Now, let us add a little bit more into this. If there are children, if the wife makes a claim for alimony, maintenance, can this be discussed? Can we draw up an agreement? So, it's not a valid marriage. ಅದು ನಾವು ಹೇಳಲಿಕ್ಕೆ ಬರೋಲ್ಲ ಅಂತ ತಾವೆಲ್ಲ ಹೇಳಿದ್ದೀರಾ, ಆಯ್ತಲ್ವಾ? ಯಾಕೆ ಅಂದರೆ ಸೆರೆಮನೀಸು ಕಾನೂನು ಪ್ರಕಾರ ನಡೆದಿದ್ದರಿಂದ ಆಗೋದಿಲ್ಲ, ಮಾಡೋಕ್ಕಾಗೋಲ್ಲ. ಸೊ ಹೌ ಡು ವಿ ಹ್ಯಾಂಡಲ್ ದಿಸ್ ನಾವು? Can we now leave this issue of validity of marriage to be taken up by the court? Can we draw up an agreement in respect of alimony, maintenance, or the educational expenses for the child, maintenance for the child, visitation rights? It can be drawn up, leaving this question on declaration regarding the validity of the marriage to be taken up by the court. So that reduces the bulk of the case to be considered over there. So now when we say declaratory reliefs are barred, but our experience in the past 15-16 years has shown that we can mediate on this and bring the parties who have differences onto the same table, or rather where there is a win-win situation for both parties. There may be many of such situations you all have handled in your cases that you have handled. Something which came to my mind, I put it onto it. Now let me take to this, I'm citing a citation, though this is not on the mediation. There is a judgment of Honorable Supreme Court, that is the Dolly Rani versus Manish Kumar Chanchala, Honorable Justice Nagaratna's judgment, where the court said when ceremonies have not been performed, it is a void marriage, and that court has to declare it as a void marriage. Now let's consider another situation where parties are Mohammedans. They have obtained, their marriages are contract. So they have obtained their kulla or a mubarat. Kulla is where a woman makes a claim and the husband agrees. Mubarat is a joint, it's a mutual consent between the two parties. One minute, ma'am. 1 minute. So, the suit has been filed for declare that the divorce they have obtained by kulla or mubarat is lawful and legal. Can that be referred to mediation? Yes? Somebody said no? See, when it is a declaration, so if I am at the party and I give a declaration to myself, is that possible or feasible? See, virtually if you see in this mutual consent, in this in Kula, something I have to give up. The lady has to give up something. In Mubarak, sometimes parties go into depth not only about the marriage, they go into depth of the rights of the claim regarding maintenance, visitation rights, etc. When it is only declaration, it cannot be done by the mediators. It is the duty of the court. Again, we have Honorable Justice Anu Shivaraman's judgment on this. There is also again, these two citations are not on mediation, but however, I thought they were relevant there, so I've just put it on. So it's not there in your compilation. So this judgment is there available, these two judgments, which will be helpful for us to understand that. ಹೌದು, ಆ ಥರ ಏನಂದರೆ A and B, husband and wife, admit that we got married, nikah on such and such a day, and we have children or whatever it is, all that stories will be there, whatever elements that have occurred, events that have occurred in their life. Now we do not want to live, and I want to obtain a divorce. Husband also accepts it and signs it. Mohammedan law, it is a contract between the two parties. So divorce is also by contract. In the Islamic law, I think it's 319 if I'm not mistaken, it provides for this, provides for Kulla and Mubarak. See the difference, Madam Prema, Mubarak is there. Prema ma'am, please read this judgment, you will get an idea about it. And also see section in the Mohammedan law, 319 section deals with this, specifically about Kulla and Mubarak also. Okay? So now let's move to the next issue that is coming up. Sorry? As mediators, if see the only thing what occurs to my mind, subject to all your clarifications, as well as this judgment is there anything dispute between the husband and wife with regards to visitations, with regards to claim of alimony, etc., then we can intervene. Otherwise, this you cannot. We as mediation center cannot go into the declaring parties have by consent obtained a decree of divorce under Mohammedan law, which is valid. So all that you require is parties want a document from the court, because this what is obtained privately is not recognized. So therefore, many of us, even before this judgment came, we were filing in the court an original suit to declare that it's a valid divorce under the Mohammedan law. Mediations, it can't be done. That declaration has to be given by the court. See what happened in this judgment, the court went into all this aspect and said the court had rejected it. Then when this matter came up before the MFA, they said no, the judgment of the family court was wrong and has said it can declare that it is a valid marriage, valid divorce, because Mohammedan law provides for it. See section 39, if you look at the Dissolution of Muslim Women Marriage Act of 1939, does not provide for mutual consent divorce. It does not provide for it. That is why the court has rejected. The family court had rejected it. But then when it went up to the court, then they said in a suit, to declare a suit, it is maintainable, it can be accepted. It may not come under the Dissolution of Muslim Marriage Act of 1939. So that is what the fine thing is. But it cannot come into the mediation is my understanding.
Marriage ಇಲ್ಲ ಅದು ಹಂಗೆ ಮಾಡ್ತಾರೆ ಸರ್. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಲ್ಲಲ್ಲ ರಿಜಿಸ್ಟರ್ ಅಂತಂದ್ರೆ ಕೊಟ್ಟಿ ಹೋಗ್ಬೇಕು ಕ್ಯಾನ್ಸಲೇಷನ್.
ರವಿ ಅದು ಸ್ವಲ್ಪ ಇದು ಮಾಡ್ತೀರಾ? ಹಲೋ ಆಡಿಯೋ ಸ್ವಲ್ಪ
ಮಾಡ್ತಾರೆ.
ಹೇಳಿ
ಎಲ್ಲ
normally in Mubarak or
ಎಲ್ಲ
the parties will come up with a document of Kula.
Madam,
privately entered among the parties. Based on that, the parties declaration of that document to be the valid and give a decree. What best mediation we can do is we can reiterate the main points, whatever is entered among the parties in the private contract, and we can give an opinion. I mean, it's not an opinion, let's send back to the court for passing an order.
Thank you, Rafinu Saban. We can discuss this in another situation. I think my personal opinion is no, it can't be done because they have already signed it between themselves. It is a valid contract which is acceptable between themselves. Yes. Even the court cannot intervene. So what are we doing here? The court only has to declare it is valid or not.
Yes.
That's all. So let us look at this judgment. I will stop the discussion on this. I will discuss with you all personally because let us look at the next scenario or the situation that we want to talk on. declaration of the suits. If it is based on title, a
Cancel.
partition suit, somebody will say a will, somebody will say gift. Can that be referred to mediation? Can we look into can we do mediation on this? Somebody says no, some of them say no. Yes, it can be.
marriage
So we can go into the mediation, talk to the parties, dehorse the title deeds. If they are willing to work on it, then it can be done. In a recent training program, the judicial officers had expressed a lot of judgments. I mean the suits are being filed where parties are eager for an agreement, compromise. So there is, I do not want to use the term collusive, but it is happening. The judges were of the opinion that we should look at the title. So when we ask for in Bangalore 2 acres of agricultural land, which part of Bangalore is still in agricultural land? It has changed its stature, nature has been changed. Buildings would have come up, many things would have happened there. So the court felt that, the judicial officers felt that we as mediator have to look into the documents they're asking for and see whether they are collusive or not. We had a discussion whether we should do it, but then the question was,
ಅದೇ ಹೇಳ್ತೀನಿ ಆಗಿಲ್ಲ
so we should look into the documents to see. The court felt that even the compromise decree made by the Karnataka Mediation Center, when the court asked for documents, the court rejected the suit. Well, that is the prerogative of the court, and the court could do it. But as mediators, when we have such a situation where you feel that there is something urgent, something compromised, or something collusive, it is there, please look into the titles is what we have, as a learning, have taken from the interactions with the judicial officers. Now let's move to the next question.
ಆನ್ಲೈನ್ ನಾವೊಂದು ಫೋಟೋ ಕಳಿಸ್ಬಿಡ್ತಾರೆ ಇದು ನಿನ್ನ ಮಗು ಆಯ್ತು
Please, any question? I'm sorry, I'm not able to hear you all. Kindly mute your microphones, please. Thank you. If there are any questions, I will take those questions also. Kindly permit me to finish this presentation. Now we have finished this about the declaration. Now pre-litigation mediation, which is not unfamiliar to us. I think I am proud of Karnataka Mediation Center, which we have started this trend from 2013. It's not only the 498A cases which are coming up, that is the dowry harassment cases which are coming up, which is now under the BNS that is coming up here, but even privately parties are referring to pre-institution mediations. They are coming up and mediators are doing handling these cases. So this came about in the case Srinivas Rao versus Deepa. When there are criminal matters, before filing an FIR, the efforts should be made by the mediation centers to see whether there can be an amicable resolution between the parties. So next one is the pre-institution, that is PLM, this is PIM. Pre-institution mediation under Commercial Court Act, is it mandatory? 12A. It is mandatory, and there is a judgment of the Honorable Supreme Court in Patel Automation case. I have raised this question here again because Section 89A has been amended recently, in the CPC has been amended. Now where all suits, civil suits are also pre-institution mediation is compulsory. So if the wordings are parametric, can this judgment be applicable to this case? That's a question I leave to you all to ponder upon. Confidentiality. We all are familiar with and saying that anything discussed or stated during the mediation, all parties and mediators are bound by confidentiality. Even though sometimes during the class or session we may bring about the facts of the case, but which party, who, name, etc. we may not be sharing. It's only a situation that we are sharing. So what are the judgments on those two? One is that Moti Ram versus Ashok Kumar. I've given you the Rule 20 of the mediation rules, then Section 22 of the Mediation Act of 2023. Motiram versus Ashok Kumar, I remember when this judgment came about, I think I was in Mandya doing a training program, 40 hours training program. This was distributed, there was a direction to distribute to all the mediation centers. When you're drawing up the mediation agreement, if it is an agreement, final settlement, mediation settlement agreement, then completely we have to write the terms. If it is not, there is no need for us to mention what was the offer, what was the term, how far we came, and when did it stop. Neither are we meant to maintain an order sheet which is maintained by the courts, not required. It's only for our own purpose. So fortunately for us in Bangalore Mediation Center, now Karnataka Mediation Center, we have had good guidance from the initial stage by ISDL, who did our training over here for a long time, who did put all the forms. Many of us may not even have seen the forms which are there. But then the staff or the director, deputy director are taking efforts to see how they are sending the report. The reports are going back saying that there is no mediation. The judicial officers asked us if there is a delay by anyone. Voluntarily, if parties have not come, they wanted us to write that, and that was conveyed to the director and deputy director. Non-cooperation of the party should be mentioned if at all it goes back to the mediation on that ground that there was non-cooperation of the parties. Now another judgment is Peri Kansagra versus Smriti. It is Madan Kansagra, not Madam, N. It is a spelling mistake. This is a judgment of the Supreme Court where matters pertaining to the children. The courts, when the child custody matters are there, they have a role of a parent's patria. At that point of time, the court had appointed the counselor to give a report on child study report, home study report, to help them take a decision regarding best interest for the child. So there was an objection that that report is confidential, it cannot be looked into. The court felt and said, and has given a ruling that in the matter of child's interest, the court can call for such a report and it is not confidential. That's an exception in the issue of confidentiality. Now let's take the other principle of mediation, parties' self-determination. Where do we see parties' self-determination? Where do we see parties' self-determination? They have chosen mediation, that is their choice as against litigation. Then the terms which they are discussing, take the mic please, Ravi Karidevarna. The terms which they are, the issues they want to discuss, the issues which they don't want to discuss, the terms which they are agreeing or not wanting to bring it on the table, it is their determination. So, if the mediation agreement goes beyond the pleadings, now suit for, it will be only, for example, it will be for restitution of conjugal rights, petition for restitution of conjugal rights, but then parties agree to go for a divorce. So then there we have to file a fresh petition. But if there is a situation there it is agreement for sale is there, a specific performance, there's an injunction suit alone filed, but parties decide comprehensively with regards to the agreement of sale. Now that can be gone into, isn't it? So where do we find the, where do we get this, this kind of right is recognized under which provision of law? Can we look into this? Section 20, Order 23, Rule 3 of the CPC provides for a compromise between the parties. If the parties are the same parties and the disputes between them, it can go beyond the pleadings in the court. Other than the prayer, you can go beyond that. So now we have AFCON judgment, para 40 and 43I makes a reference to this in the, that parties can go beyond the pleadings. Now, another judgment which came about in the Supreme Court in 2019 is a contempt petition Kaushalya versus Jodaram. That was a suit for injunction filed between the father and daughter in respect of one property. But it came up before the Supreme Court. Supreme Court referred the matter to the mediation. In the mediation, father agreed to buy a property to the daughter and daughter agreed to give up two properties. One property which was subject matter of the suit in the trial court, another property additionally which the father owned, and she was partly in possession of that. So she gave up that also. Joda Bhavan and Meera Bhavan, two Bhavans were there. That was the list of that particular litigation. Then that was entered into an agreement that became a judgment. Now, whatever reason, the daughter did not give partly, the father, so therefore the father did not give the property, though he had purchased it, he did not give it to her. So daughter filed a contempt petition, and in the contempt petition, in the execution case, the father filed an execution case. In the execution case, the defense was taken that in the original suit only one property was there. Joda Bhavan was not a part of it, therefore the execution court cannot go through it. So when and there were others who made a claim on it. There was agreement of sale by two other parties who claimed that there was partly they are in possession of the properties. So they were the obstructors. So when the matter was in Supreme Court, the Supreme Court said, though in the mediation, though that was not a part of the suit, if parties have agreed and gone into that list completely, that will be binding, notwithstanding the fact that it was not a part of the earlier pleadings. I would like to read one paragraph in para 12 of this particular judgment. In the mediation, it's always open for the parties to explore the possibility of overall amicable resolution or settlement, including disputes which are not the subject matter of the proceedings before the court. That's the benefit of the mediation. Amicable settlement reduced into writing, spelling mistake, becomes part of the court's order. Mediation settlement agreement is executable irrespective of the fact whether the mediation settlement agreement is in respect of the properties which was not subject matter of the proceedings before the court. It is binding on the parties, required to be acted upon, complied, and is executable. This was another question that was asked by the judicial officers in executing court, whether I should follow the judgment of the Honorable High Court confirmed in RSA, or in execution case the matter was referred to mediation, and mediation there are changes. What should we follow? This is where there is a role or a heavy duty on the mediators to ensure that the drafting of the mediation agreement is in such a manner where you will confirm part of the decree or the judgment of the Supreme Court or the High Court, and where you are going to differ and what has to be done. In any event, any property title deeds are there. In addition to the agreement, there should be registration of the property should be there. So now what we should do is that drafting of the agreement when such situation comes about is very important, and we have to pay attention there. Well, I think that will be another topic for discussion. Let's move on to the next topic. Another party's right to self-determination. There are these two judgments where section 13(1)(a) or B petitions, we are drafting mediation agreement in that petition itself, and the decree of divorce are also granted in the same petitions. This did not happen overnight. All over India, everybody are filing a 13B petition independently after the mediation agreement is done. But we were fortunate that petitions went to the Honorable High Court. Honorable Justice Ajit Gunjal and the second judgment by Honorable Justice Bopanna, as he was then, have given a ruling that what is the spirit of mediation? Spirit of mediation is to end the litigation between the parties and not to push them to file more cases against each other or whatever. And the consent is subsisting, and parties are intelligent enough or mature enough to understand the implications of the outcome. And therefore, the court said that this case, 13(1)(a) or 1B, can also be, settlement can be recorded in the same petition, and fresh petition is not necessary. Can the mediation agreement be challenged? We all have learned that it is full and final, it is enforceable, it attains finality. Where have we seen the mediation agreement reopening? Sorry? Madakagalla, madbardu. Fraud, misrepresentation, you have to file a writ petition. Writ petition has to be filed. But in case of a child's rights are there, child's rights, the Supreme Court judgment in Rosie Jacobs' case, which came about in 1973, has laid down that there is no finality, there is, until the child is minor, change circumstances, even the judgments of Supreme Courts are not final, there is no res judicata, there is no estoppel. So similar line, we had our High Court judgment Suma Hanumantappa versus Raghuram Shanmuga Sundaram, Honorable Justice B.S. Patil's judgment, where the court has held, reiterating the same situation, that you cannot reopen the decree of divorce as granted, but the issue regarding the child's rights, that is visitation rights or custody or guardianship, can be reopened. It can be done under section 26, application under section 26 and miscellaneous petition, or filing a GNWC case. But however, me and Shivakumar had a disagreement on that. He felt it has to be miscellaneous petition. Our late Shivakumar, I'm remembering him now. Whether power of attorney can participate in the mediation? Yes. There was in one of the cases that court did not allow. So we have Honorable Justice Nagratna's judgment here in Aditya Jagannath another versus Nil, where a power of attorney can participate in the mediation. So I quickly go through the next thing. We have had situations. There's a mediation agreement between husband and wife. Partly they comply with it. Some payment has been made. In the agreement it comes, the rest to be paid before the court. Now the party does not turn up before the court. So I have three questions. One, what should the court do there? No, I just moved this. Can the court grant a decree of divorce? Does it amount to contempt by the party who did not come before the court or comply with the mediation settlement agreement? Can the court go back to status quo ante, meaning whatever benefit that the lady had got by receiving the money, can that be returned back to the husband? Can it be done? These are the issues that were raised in the courts. But then I will add another question. We have seen such situations happening even here. Mediation agreement OP sign ಮಾಡಿದ ನಂತರ ಕೋರ್ಟಿಗೆ ಹೋಗದೆ ಬರದೆ, ಅಥವಾ there are some cases agreed to pay certain amount, and based on that consent gone and withdrawn the petition they had filed in the courts, and thereafter he did not comply with it. Then the lady had to run around in the courts to get her rights again with a litigation. So as mediators, how do we ensure that this situation do not occur, or can we prevent it? So these are two questions that I would put it to the group for us to discuss here. Before I go to the role of mediators, let me look into this. What did the Delhi High Court say? In the Delhi High Court judgment, some courts said if it is acted upon partly, then absence of a person does not stop, because she has consented and signed the agreement and therefore granted a decree of divorce. Some other judgment said no, it can't be granted. So when the matter went to the larger bench, in this judgment, Rajat Gupta versus Rupali Gupta, Justice Hima Kohli has gone into the details of all this and said the consent of the party must be subsisting at the time when the judge is passing an order. So therefore the court can't grant a decree of divorce. That means the court has to go by the trial and then pass a decree of divorce based on the merits of the particular case. So now she has got an advantage of certain money. What do we do with that? Can we issue a warrant? Can we go for a contempt? It can be contempt provided we use the term in our drafting. The term is undertaking to appear before the court or undertaking to do certain things. When we use such a term, that could be termed, can be said, it can amount to a contempt. But however, there is a caution by the Delhi High Court saying that it should be used rarely. But however, the trial had to go on and then the court granted a decree on that. There is another judgment of Honorable Supreme Court. In similar circumstances, the court granted a decree of divorce. Now, which should the courts follow here? Supreme Court uses the power under 142. That power is not available for the courts here. So it can't be done by the courts here. So therefore, the onus is on us to ensure, as mediators, we balance the rights of the parties. Payments, if any, earlier they were giving cash, payments were being done in our presence, then we know the amount is given and the lady goes out, it's snatched from her hand. So we have changed over the period of time mediation, we have ensured that payments are by DD. We enter the names, payments to be made in the court. So there are three methods which we have adopted. That is, one, payments to be done in the court, or that DD details are written there, or deposits in the family court, or an escrow account. Sometimes parties have requested the director of the mediation center to keep it here. ಮೇಲ್ಗಡೆ ಮುಗಿಸ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ತೀವಿ, ಅದಾದ್ಮೇಲೆ ಇಲ್ಲಿ ತಗೊಂಡು ಹೋಗ್ತೀವಿ ಅಂತ. It has been left to the directors of the mediation center to take a call whether they want to keep it or not. But most often they have not cooperated because they do not want to take a responsibility on that. So escrow account, when you said keep it with somebody who is trustworthy between the two parties. So this is regarding this. The last two slides that I would like to take on is in a mediation, when you're drafting a mediation agreement, can a mother give up the maintenance on behalf of the minor child? Father can give up his claim, because often we see, avanu ದುಡ್ಡು ಕೊಡಲ್ಲ ಅಂದರೆ ನನಗೆ ನಮ್ಮ ಮಗುನ ಕಳಿಸಲ್ಲ. So no visitation rights, no money. That's what we hear very often during the mediation. So how do we handle such situations? So can we say that he will not get the visitation rights, so she will also not make any claim on the child now or tomorrow or in future? Can it be done? Why, ma'am? Ma'am, we were also doing that earlier. We were also drafting in that manner because we felt that it was the party's decision, party's right to determine what they want to do. But there was a judgment of the Supreme Court, Supreme Court, the case came about. Ravi, barta illa. Well, that judgment is there in your folders. That is the Sudhir versus, what is the judgment there? Sudhir versus Ganesh, there's a judgment where the Supreme Court held Ganesh Sudhir versus Srivatsa, 2020, volume 20, SCC. The Supreme Court said, yes. The father may give up his right to claim visitation rights. That is my right, I give up. But a mother can give up her claim for maintenance, but not that of the child. So the Supreme Court, though it was granted by the courts, in the lower courts in the family court, in the matter came up to the Supreme Court, Aurangabad court had granted this agreement, it was stuck off in the Supreme Court after many years. So the Supreme Court in Ganesh Sudhir versus Srivatsa and others, this particular judgment 2020 has held that mother cannot give up their claim on behalf of the minor child. As the role of a parent's patriarch, the court can take a call to say it is for the child to decide what she wants to do. So how do we word that? So now we are carefully wording who takes on the responsibility completely. So without mentioning this, if that is what the parties want, we say that X is taking on the complete role and there's no mention about giving up the claim. I think we are doing that, but if you want to discuss on this, we will go. Anyway, Geeta Hariharan's judgment is not relevant here for the moment. Now let me move to the last two issues, that is criminal cases, which Raji Madam was just mentioning, that when the cases are coming up before us, before the mediation center, and compromise has to be done. Can criminal cases be referred for mediation? If so, which cases? All right, now let us go into looking into section 320 of CRPC, which is now 359 of BNSS, which says that it is compoundable. Such cases can be gone into. And then we had this, in 2010 we had a judgment of the AFCON judgment which said criminal cases we cannot do the mediation. 2013, Gyan Singh versus State of Punjab, 2012 this judgment came about, said in 498A cases which the nature of dispute is civil in nature, that can be referred to mediation and you parties can compromise that, and the petition was quashed. So therefore the duty of the mediators in cases where we have criminal cases coming, we have seen cases where bail matters are also being referred, where basically the flavor of the litigation dispute between the parties are civil in nature. For example, it may be a partition suit, it may be assault case, it may be neighbors dispute, then it goes into a criminal case also. In such cases where the genesis of the dispute is in the civil arena, then that can be looked into or can be quashed and the mediation can be done. Now, there is this judgment, Parbat by Hahir versus State of Gujarat, 2017, where the court has given a guidelines which are the cases which cannot be compromised, where there is an intention to deceive, where there is a fraud, where there is misrepresentation, where there is a forged documents, where there is using a GPA, I have appropriated certain things. Such cases cannot be mediated where fraud is inherent in the action of the party. Such cases cannot be mediated. Now, why we should as mediator, the other things that we look into is whether rape cases can be referred to mediation. They have not been referred so far. POXO cases and this issue of rape cannot be compounded or cannot be compromised because it is against the public policy and those cases cannot be compromised. The courts are very harsh in such matters. So what we should do as mediators when we are drafting the agreement, please ensure, I think there's a Delhi High Court judgment which I have referred in the last but one page. Chhatrapat, there's a guidelines given by the Delhi High Court, I have not put up here, where the court has said, in case of criminal matters, Chhatrapat Pal 2023 Supreme Court on Delhi High Court judgment, where the court has said what are the guidelines, what we should do as mediators when there are criminal cases. The cases which cannot be compounded. Go back to these two judgments, State of Gujarat versus Punjab, Gyan Singh's case and Parbat Bai's case. Please remember these two judgments, go through these judgments and get clarity on what are the cases that mediation, that the compromise can be entered into. Then even if it's not, the court has a right to reject it. But then should we go into that? Last issue. So far, earlier when we came here, Negotiable Instrument Act was being referred to, the NI Act cases were being referred to. Now this has been stopped. I don't know why or what. I have just read in the newspaper recently, it's in news that more than 40% of the cases pending in the courts are pertaining to the NI Act. So I won't be surprised that shortly we may have cases referred to or coming back into the mediation or looking at a compoundable situation which can be done. So how do we draft that mediation agreement in such cases? Now we could see that there's an amount of payment of amount is there. For the recovery, some check would be given, the check would have bounced, then they have to file the case. 138A proceeding is compoundable. So you can enter into a compromise in that. 148. Now suppose I agree to give back the entire amount, it ends in an acquittal. Suppose I pay partly and partly I say will be paid later on. And he fails to pay, but he is acquitted. Based on the compromise, there is an acquittal. So now what do the party do? Make FLW ಗೆ ನಮ್ಮ compromise petition ಅಲ್ಲಿ ಬರ್ದಿರಬೇಕಲ್ವಾ? Yes, you can do that. If there is a default, we had earlier Govindan Kutti's case on Honorable Supreme Court judgment in 2012, where it said you can file a suit for execution. But suit for execution is again a civil procedure, it takes its own time. And can we do, as Rajeshwari was mentioned, whether FLW can be done? Yes, it can be done under 421 and 431. Sorry, I have not put on the BNSS sections here. Fine levy warrant can be done. These are the 4 judgments of the Honorable High Court, unreported judgment. The first judgment is by Justice Anand Bhaira Reddy. The second judgment is again by the Justice Suraj Govind Raju. Then we have Amaranavar, and the last one is by Delhi High Court. Delhi High Court judgment is very interesting. If you can read this Dayavati versus Yogesh Kumar, whether mediation centers can take up cases under NI Act, and if so, how, where, etc. It's not necessary for me to go into it. But what these judgments, number 2 and 3 has said is that in our mediation agreement, we should make a reference, and undertaking is given by this, the party. Default clause should be there. In the default clause, he should agree for recovery by fine levy warrant. If it is not there, you have to go back to civil case of recovery through civil execution. So now the question, they are acquitted. Can we recall that acquittal and have a conviction? Can the trial go on? Now I will make a application to the same court. Can the court, once it's acquitted, can the court have a power to recall the order and go on to the trial?
No, it is not. He has to approach district court.
He has to approach writ petition.
Writ
They have to file a writ petition. That's where we get the clue from. Even acquittal orders cannot be set aside like this or cannot be reopened. But if with mediation agreement we can have this being included and drafted upon, then yes, it is possible. But it is in the High Court. That's where Honorable Justice Nagaprasanna came about this judgment. Hemchandra versus Kuppalli, it's 28/2/2024. Acquittal order was set aside. Lok Adalat.
Yes.
It was, nowadays cases are not coming to mediation center, it will be in Lok Adalat. See, again under 490, if it is under Negotiable Instrument Act, they have to pay against, as per the Damodar Prabhu's case, they have to pay the fine amount 10%, 15% has to be paid. Even that was not paid. The court felt that was a fraud played on the court just to avoid his conviction, and therefore recalled the order of acquittal, and that matter remanded back for trial again. So the order of conviction was there and the matter was restored back in the appeal stage. So what is important for us here is to see how we have to do the drafting in the mediation agreement. So important is to see that we are balancing the interests of both parties and ensuring that we are not pushing them to the courts again, and how we can ensure that both interests are equally balanced. Any questions? I think I'll stop here. I've gone beyond the time, 5 minutes, 6 minutes beyond 5:35. Any questions? I will take it from you. Dharwad and Gulbarga, if you have any questions, please. Participants, our mediators and friends from Dharwad and Gulbarga, any questions, please? Mute Madidara, Ravi.
Sir, please unmute yourselves.
Ravi, any questions? Friends from Dharwad and Gulbarga?
No questions from Dharwad benchman.
Thank you. Gulbarga? Anybody else? Any questions here?
ಮೇಡಮ್
Yes, sir. ಹೇಳಿ.
ಮೇಡಮ್ ಮೊನ್ನೆ ನಮಗೆ ಟ್ರೈನಿಂಗ್ ಮಾಡಿದ್ರು ಧಾರವಾಡದಲ್ಲಿ.
ಹಾ, ಹೇಳಿ ಸರ್.
ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಮೀಡಿಯೇಷನ್ ದಲ್ಲಿ ನಾವು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ತಗೊಂಡು ಅದನ್ನ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಇದನ್ನ ಮಾಡಕ್ ಬರಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅದೇನಿದ್ರು ಕೋರ್ಟ್ನವ್ರು ಅಷ್ಟೇ ಮಾಡ್ಬೇಕು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಮೇಲೆ. ಮತ್ತೆ ನೀವ್ ಹೇಳಿದ್ರಿ ಈಗ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿನೂ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿದ್ರಿ. ಇದು ನಮ್ಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಒಬ್ರು ಹಂಗ ಹೇಳಿದ್ರು, ಒಬ್ರು ನೀವು ಹಿಂಗ ಹೇಳ್ತಾ ಇದ್ರಿ.
ಸರ್, ತಮ್ಮ ಪ್ರಶ್ನೆ ಇರೋದು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಬಿಡಕ್ಕಾಗೋದಿಲ್ಲ ಅಂತ ತಾವು ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಅದು ಟ್ರೈನಿಂಗ್ ನಲ್ಲಿ ತಿಳಿಸ್ಕೊಟ್ರು ನಿಮಗೆ. ಬಟ್ ನಾನು ಇವಾಗ ಹೇಳಿರೋದು ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
ಹಲೋ,
Namaskara, sir. Nanu Lakshmish, sir.
Namaskara.
We were the trainers there. What we said was, we cannot accept the general power of attorney in mediation. ಅದು ಕೋರ್ಟ್ ಮಾತ್ರ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡೋಕ್ಕಾಗುತ್ತೆ. ಒನ್ಸ್ ದ ಕೋರ್ಟ್ ಇಸ್ ಆಕ್ಸೆಪ್ಟೆಡ್ ದ GPA, ದೆನ್ ವಿ ಕ್ಯಾನ್ ಡೂ ಇಟ್. ಬಟ್ ಇಟ್ಸ್ ನಾಟ್ ಫಾರ್ ದ ಮೀಡಿಯೇಟರ್ಸ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ದ GPA. ಅದನ್ನು ನಾವು ಹೇಳಿದ್ದು ಸರ್. ಕೋರ್ಟ್ ಮುಂದೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕು. ನಮ್ಮ ಮುಂದೆ ಅಂದರೆ ಮೀಡಿಯೇಟರ್ಸ್ ಮುಂದೆ ದ ಪಾರ್ಟೀಸ್ ಕೆನಾಟ್ ಗೆಟ್ ದಿ GPA. ತಿಳಿತಾ ಸರ್? ಅರ್ಥ ಆಯ್ತಾ? It is for the court to accept the GPA and proceed. It is not for the mediators to take a call on that. ಕೋರ್ಟು ಒಪ್ಕೊಂಡಿದ್ರೆ ಜಿ ಪಿ ಎನ, ದೆನ್ ದ ಜಿ ಪಿ ಎ ಕ್ಯಾನ್ ಆಕ್ಸೆಪ್ಟ್, ಐ ಮೀನ್ he can come and participate in mediation. ಕ್ಲಿಯರ್ ಆಯ್ತಾ?
ಬೀನಾ ಮೇಡಮ್ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ,
ಈಗ
ಮೊದಲನೇ ಬಾರಿಗೆ ನಮ್ಮ ಮುಂದೆ ಮೀಡಿಯೇಟರ್ಸ್ ಮುಂದೆ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಕೋರ್ಟ್ನಲ್ಲಿ ಅರ್ಜಿ ಹಾಕಿ ಕೋರ್ಟಲ್ಲಿ ಆಕ್ಸೆಪ್ಟ್ ಆಗಿದ ನಂತರ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಬಂದಾಗ ಅವ್ರನ್ನ ಪರ್ಮಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ. ಒಂದು. ಎರಡನೇದು, ನಾವು ಸಹ ತೆಗೆದು ನೋಡ್ತೀವಿ ಅದನ್ನು, ಅದು ಕರೆಕ್ಟಾಗಿ ಅವ್ರಿಗೆ ಪವರ್ಸ್ ಇದೆಯಾ ಇಲ್ವಾ. ಒಂದೊಂದ್ಸಲಿ ಮೀಡಿಯೇಷನ್ ಅಪೇರ್ ಆಗೋದು, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಇರೋದಿಲ್ಲ, ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಇರುತ್ತೆ, ಆವಾಗ ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಈ ಹ್ಯಾಸ್ ನೋ ಅಥಾರಿಟಿ ಟು ಸೈನ್ ದ ಡಾಕ್ಯುಮೆಂಟ್. ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಅಲ್ಲಿ ಗಮನಿಸ್ತೀವಿ ಆ ಥರ. ಬಟ್ ಅದು ಇಟ್ಸ್ ಫಾರ್ ದ ಕೋರ್ಟ್ ಟು ಪರ್ಮಿಟ್ ದ ಪಾರ್ಟಿ ಟು ರೆಪ್ರೆಸೆಂಟ್ ದಿ ಪಾರ್ಟಿ. ಅಂದರೆ ಈ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿನ ಈ ಪ್ಲೇಂಟಿಫ್ ಡಿಫೆಂಡೆಂಟ್ನ ಅವ್ರ ಪೆಟಿಷನರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ನ ಪರ್ಮಿಟ್ ಅವ್ರನ್ನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋಕ್ಕೆ ಪರ್ಮಿಷನ್ನ ಫಸ್ಟ್ ಕೋರ್ಟ್ ಕೊಡಬೇಕು. ಅಲ್ಲಿ ಅರ್ಜಿ ಹಾಕಿ ಅಲ್ಲಿ ಅಲೌ ಆಗಿದ ನಂತರ ಮೀಡಿಯೇಷನಲ್ಲಿ ಅಲೌ ಮಾಡೋಕ್ಕೆ ಅವಕಾಶ ಇದೆ. ಮೊದಲನೇ ಬಾರಿಗೆ ಮೀಡಿಯೇಷನಲ್ಲಿ ಆ ಇಶ್ಯೂ ತರೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಬೀನಾ ಮೇಡಮ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ಟರು.
ಅದೇ ಈಗ ನಮ್ದೇ ಒಂದು ಇವತ್ತೇ ಇತ್ತು, 3 ಜನ ಅಪೆಲೆಂಟ್ಸ್ ಇದ್ರು, 2 ಸಿಸ್ಟರ್ಸ್ ಬರಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಒಬ್ಬ ಬ್ರದರ್ಗೆ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಕೊಟ್ಟಿದ್ರು ಅಪೆಲೆಂಟ್ ನಂಬರ್ 1ಗೆ. ಅದಿನ್ನು ಕೋರ್ಟ್ ನಲ್ಲಿ ಹೋಗಿಲ್ಲ, ಈಗ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು ಅದು. ಅವ್ರಿಬ್ರು ತರಪಿ ತಾನು ಸರಿ 3 ಜನ ಅಪೆಲೆಂಟ್ಸ್, ಅವರು ಎಲ್ಲಾರ್ದು ಸೇರಿ ನಾ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಹೋಲ್ಡರು, ನಾನೇ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೋತೀನಿ ಅಂತ ಬಂದಿದ್ರು ಅವರು.
ಸರ್, ಆರ್ಡರ್ 3 ರೂಲ್
ಅದನ್ನ ನಾವು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ಕೋರ್ಟ್ ಕಳಿಸೋಲ್ಲ.
ಆ ಪವರ್ ಇರೋದು ಯಾರಿಗೆ ಸರ್? ಕೋರ್ಟಿಗೆ ಅಲ್ವಾ ಸರ್? ವಿ ಹ್ಯಾವ್ ನೋ ಪವರ್ ಆಸ್ ದ ಕೋರ್ಟ್. ಸೊ ಅಲ್ಲಿ
ಡಿಸೈಡ್ ಮಾಡಿ
ನೀವು ವಾಪಸ್ ಕಳಿಸಿ ಸರ್.
ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ಕಳಿಸೋಣ
ಸರ್.
ಈ ಒಮ್ಮೆ ಮತ್ತೆ ವಾಪಸ್ ಕಳಿಸಿ.
ಹೌದು ಸರ್, ವಾಟ್ ವಿ ಡೂ ಇಸ್ ದಟ್, ಹೌದು ಸರ್, ನಮ್ಗೆ ಅಧಿಕಾರ ಇಲ್ಲ ಆಸ್ ಮೀಡಿಯೇಟರ್ಸ್. ಇಟ್ ಮೇ ಗೋ ಡಬಲ್ ಟಾಸ್ಕ್ ಆಗ್ಬೋದು, ಇನ್ನೊಂದ್ಸಲಿ ಹೋಗ್ಬೇಕು, ರೆಫರೆನ್ಸ್ ಮಾಡ್ಕೊಂಡು ಬರಬೇಕು, ಅಲೋ ಮಾಡ್ಬೋದು, ಟೈಮ್ ಲ್ಯಾಪ್ಸ್ ಆಗುತ್ತೆ. ಬಟ್ ನಮ್ಗೆ ಅಧಿಕಾರ ಇಲ್ಲ, ದಯವಿಟ್ಟು ಆ ಥರ ಮಾಡಲಿಕ್ಕೆ ನಮಗೆ ಅಧಿಕಾರ ಇಲ್ಲ, ಅದು ಮಾಡೋಲ್ಲ ಅಂತ. ದಟ್ಸ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಬೀನ್ ಫಾಲೋಯಿಂಗ್ ಹಿಯರ್ ಸರ್. ಅದು ಬೀನಾ ಮೇಡಮ್ ಆ್ಯಂಡ್ ಲಕ್ಷ್ಮೀಶ್ ಸರ್ ಇಲ್ಲಿದ್ದಾರೆ, ಅವ್ರ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಕೋರ್ಟಲ್ಲಿ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ ನಂತರ ಇಲ್ಲಿ ಅಲೋ ಆಗುತ್ತೆ ಸರ್. ನಾವು ಆ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಈಗ 3 ಜನದ ಬದಲಾಗಿ ನಾನು ಒಬ್ಬರೇ ಸೈನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಕೋರ್ಟಲ್ಲಿ ಪರ್ಮಿಷನ್ ತೊಗೊಂಡೇ ಬರಬೇಕು ಸರ್. ಅಧಿಕಾರ ನಮಗಿಲ್ಲ. Well, friends, thank you. Any other question apart from this?
Geeta, for that, it's the opening statement that every mediator does. In the beginning itself, we find out who are the parties sitting there. Then we come to know that, okay, somebody is with a authorization or with the power of attorney. Then we find out whether that power of attorney is also filed in the court. That's the way to go. And there is no confusion beyond that.
ಮಗ ಅಬ್ರಾಡ್ಗೆ ಹೋಗ್ಬಿಟ್ಟಿರ್ತಾನೆ, ಆವಾಗ ಅಪ್ಪ ನೀನು ನನ್ನ ಬದಲಿಗೆ ಅಂದ್ಬಿಟ್ಟು ಒಂದು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಪ್ರಾಪರ್ಟಿದು ಇಲ್ಲ ಯಾವುದ್ರದ್ದು ಕೊಟ್ಟಿರ್ತಾನೆ. ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಮೀಡಿಯೇಷನ್ಗೆ ರೆಫರ್ ಆದಾಗ ಮೀಡಿಯೇಷನಲ್ಲಿ ಇದನ್ನ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾನೆ. ದೇ ಹ್ಯಾವ್ ಟು ಸೀಕ್ ಎ ಪರ್ಮಿಷನ್ ಥ್ರೂ ಕೋರ್ಟ್, ದೆನ್ ಓನ್ಲಿ ದೇ ಕ್ಯಾನ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಇನ್ ದ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್. ದಟ್ ಇಸ್ ದ
That's okay. You can have it. Any other question? Any other question? We have not short on the time. Bang on, within an hour's time we are finished. Thank you very much. I thank all the mediators. I thank the director and the deputy director of the Mediation Center for giving me this opportunity of sharing my learning with you all. Thank you very much. Thank you, Ravi, Jagdish, and others who have cooperated in making this event a success. Thank you.
ಒಂದು ನಿಮಿಷ. ಈಗ ರಿಗಾರ್ಡಿಂಗ್ ಗೀತಾ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ಒಂದು ಸ್ಪೆಷಲ್ ಕ್ಲಾಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಮೊಹಮ್ಮಡನ್ ಲಾ ರಿಗಾರ್ಡಿಂಗ್ ಮ್ಯಾರೇಜ್, ಕುಲ್ಲಾ ಆ್ಯಂಡ್ ಮೊಬಾತ್, ಅದ್ರ ಬಗ್ಗೆನೇ ಸ್ವಲ್ಪ ಹೇಳಿದ್ರೆ ಈ ಹೊಸ ಮೀಡಿಯೇಟರ್ಸ್ಗೆ ಲಾಟ್ ಆಫ್ ಕನ್ಫ್ಯೂಷನ್. ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ, ಅವ್ರು ಹೇಳಿದ್ದಾರೆ, ಲಾ ಹೇಳಿದೆ ಅಂತ, ಅದ್ರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಕ್ಲಿಯರು. ಆಮೇಲೆ ಕಸ್ಟಡಿ ಆಫ್ ದ ಚಿಲ್ಡ್ರನ್, ನೀವು ಹೇಳಿದ್ರೆ ಮೇಂಟೆನೆನ್ಸು ಕೊಡದೆ ವೇ ಆಫ್ ಮಾಡಿ ಐ ವೋಂಟ್ ವಿಸಿಟ್ ದ ಚೈಲ್ಡ್ ಇನ್ ದ ಫಾದರ್ ಕೆನಾಟ್ ಅಲೋ ಅಂತ, ಅದ್ರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಕ್ಲಿಯರಾಗಿ ಪ್ರಾವಿಷನ್ನು, ಸೆಕ್ಷನ್ನು, ಆಮೇಲೆ ಹೈಕೋರ್ಟ್ ರಿಪೋರ್ಟ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿಪೋರ್ಟ್ಸ್ಗಳನ್ನ ಸೈಟೇಷನ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ಸ್ವಲ್ಪ ಎತ್ತರ
ನಮ್ಮ ಡೈರೆಕ್ಟರ್ ಹೇಳೋಣ, ನೆಕ್ಸ್ಟ್ CME can be going on those topics. I quite agree with Rajeshwari that we have to be very, very cautious. The onerous responsibility is on the mediators. As of today, we have the court screening our agreement. We have the director screening the agreement. Then it goes to the judge and judge accepts, then it becomes an order. Imagine a situation 2023 Act comes into force. The moment the agreement is signed and you also sign, it is binding, it's enforceable. So therefore, our role and duty as when you're drafting the agreement is quite onerous, it's quite serious. So I think we should go in the refresher courses that we are doing in the district. We do concentrate on drafting of the agreement. One full session will be there on that. Thank you, ma'am. Thank you for the suggestion. Thank you, one and all who have been here, who have participated, who have enriched this program here. It's my pleasure to be with you all. Thank you very much. Those who are in the mediation center and offline too. Thank you.
Good evening, one and all. I hereby convey my heartfelt thanks to our advocate, senior mediator and trainer, Srimati Geeta Devi M. Papana, for conducting a very excellent and thought-provoking CME program today on the concept of mediation precedents. I sincerely convey my heartfelt thanks to the Honorable President and Board of Governors for supporting this CME program. I also sincerely convey my heartfelt thanks to the Registrar General of High Court of Karnataka, Bangalore, and Additional Registrar Generals of Kalburgi Bench and Dharwad Bench of High Court of Karnataka for supporting and encouraging today's CME program. I sincerely convey my heartfelt thanks to the Honorable Director and Deputy Director for allowing us to conduct this month's CME program. I sincerely convey my heartfelt thanks to all the coordinators and mediators who are gathering in large number and supported this CME program by understanding the very thought-provoking speech of trainer Geeta Devi Papana. I also convey my sincere thanks to the staff of Karnataka Mediation Center and technical crew who arranged the live telecast of this CME program through YouTube channel. Thank you one and all. Jai Hind.